All right, you've made it to chapter 15. So I'm going to be talking about the schedules in this chapter. As I've said before with the prior videos, once we got into the specifics of the petition, I recommend you have the petition in front of you or if you're using software so you can follow along at the same time so it can make more sense until once I'm done with this, I'm going to make the videos going over every single section of the petition as well. All right. That'll be able to help out paralegals and those that are going to be filing on their own for bankruptcy. All right. So take care, and I'll see you now with the PowerPoints. So welcome to chapter 15. Now, as you can see there by the title, I'm going to be focusing on some of the issues you should be facing or could be facing when it comes to dealing with the schedules, dealing specifically with debt, with whether it's secured or unsecured. Now, as I've mentioned before over the last few videos, since now we're getting into the details, again, I will post when I get around to it, right? It'll take some time, but I am going to post going over the petition and completing a petition. But for now, it's probably best that you have the petition in front of you so you can see the different parts that I will be going over. Now, we're going to start with the creditors, and I've probably said this before, but it has to be said again. All creditors. You don't get to pick and choose which creditors are going to make it onto the bankruptcy petition. Everyone's included. Now, that doesn't mean that you're surrendering your car because sometimes clients do ask that. They say, well, I'm not putting in my car because then I'm surrendering it. That's why it's so important when you go over the intake with the client to make sure that the car is listed. Sometimes clients just say automatically, well, I'm not going to, you can put a disclaimer there, put it, and they're still going to do it. So you should always review the intake with the client. But now, what I also mean by creditors, um, all of them, and that includes student loans, for example. Are you going to wipe out student loans by filing the bankruptcy petition by itself? No. Maybe that day will come, but we're not there right now. You have to go through the whole adversary process. So even student loans would get included, and that's actually something that sometimes helps clients because it increases the amount of expenses that they have. So sometimes you have to tell clients put student loans in there. Now, sometimes it's put in because the student loan lender is not being reasonable. So there's no choice but to go ahead and file for bankruptcy anyway. Excuse me. And then by putting the student loans in there, the creditor, whoever is the servicer, receives that. And then they're more willing to give the client more time or even reduce their expenses. But there's your example that all debts are going to be included. So all debts, secured debts, right? Car loan or mortgage, unsecured priority. You can see the types there that we have. Doesn't mean you're going to wipe out those debts again, but they're still going to get listed. And of course, Schedule F is probably the more common that we will be dealing with, which is typically, the personal loans and credit cards. Now, it's important to note that when it comes to unsecured, don't forget this right here. A deficiency judgment, it's, if you surrender your car, that car gets sold off at an auction. And so if you owe 20,000 and the car only sold for 10, there's still a $10,000 balance on that loan. Same thing happens when it comes to mortgages and the house is sold, in the foreclosure and the courthouse steps, like they like to say. When that happens, you should put on Schedule F deficiency judgment. Now, it's possible you don't know what the balance is. That's fine. Just putting deficiency judgment is a good way to make the trustee aware of this. And for one simple reason is, imagine there's two car repos and that's $60,000. All of a sudden we went from 25,000 in credit cards to another 60. So now we're at 85,000. That could lead to questions even from the U.S. Trustee's office because it wasn't clear on how this was categorized. So it's always important to categorize the debt correctly. Most bankruptcy programs will allow you to, list, what type of debt it is, or you can add your own. But you should always put in the description something as simple as that, as a deficiency judgment, so that it's clear we're not just talking about credit card debt. Now, likewise, besides including all creditors, all the contact information should be posted there. A lot of times you might have incomplete information from the client, but that's okay. That's what the credit reports are for. So you can get, the full mailing address and everything else, even though most creditors are going to be on the email list of the courthouse, they should still have all the correct information anyway. If not, it gets kicked back to you, especially with debt collectors, and then you have to file an amendment to that. That's just more time and more money being wasted for no reason at all. Now, always put the day the debt was incurred, and I'll tell you why. If today is the 1st of December, and let's say it's 2024, which it is, what if there's $8,000 in debt and then the date incurred was just last month? This is a lot of questions you need to ask, just to make sure that maybe it wasn't really 2023 and it was just a mistake, or maybe it was. And if it is just just 1 month ago, how do we get from 0,000 to $8,000 in a matter of 30 days or less? So you should put the date incurred because the trustee will ask that. And likewise, when it comes to account numbers, you can mask that on most bankruptcy petitions, so it shouldn't be a problem. If you're doing it by hand, then just put the last four digits of the account number should be good enough. Remember, creditors are going to go based on social security numbers, not necessarily the account numbers. Now, executory contracts, it's basically a lease, right? It's a fancy legal way of saying lease. So there's nothing to, when it comes to dealing with the issues of exemptions, and notice again that this is a different part of the bankruptcy petition. We're now on Schedule J. There's nothing to exempt. You don't own it. You don't own a lease until that lease is up, and then you decide to purchase it. It's a lease option, with a lease with an option to buy. Now, a lot of times I see the confusion with that, but I always tell people, whether it's other lawyers or paralegals or even debtors that have come to me, I say, do you own your apartment? No, I rent it. It's a lease. Right. So you're going to exempt your apartment under real estate? No, of course not, because you don't own the apartment, and the car is no different. Okay. But there are other sections you do have to worry about, just to make sure whether they're going to keep the lease or they're going to reject it, basically surrender it. If it's surrendered, remember, we're going back to that deficiency balance. At this point, if the bankruptcy is filed tomorrow, surrendered 3 days ago, obviously we're not going to have the full deficiency balance because there's no way it went to auction at that time. But, you can easily guess. Just look at the last statement. If the last statement was there's a $25,000 balance, that's good enough. Just put that there's a $25,000 balance and you're good to go. Now, when it comes to Schedule H, all we're putting is codebtors. Now, I'm going to get into this one because this is an issue, but first, let me be clear that, with the co-debtor, co-signer, there are two people on that debt. I don't care if we're talking about a car loan or we're talking personal loans or credit cards. If one person files for bankruptcy, then the other person simply owes that full amount. Doesn't matter whether they're husband and wife, doesn't matter whether they're separated, best friends, cousins, brothers, sisters, they are going to be liable for that debt 100%. The problem is right here when it comes to divorce agreements. It is standard language in a divorce agreement to put that, what we call the hold harmless clause, meaning this person isn't going to be responsible for that car loan. Now, that when that person, so we have here, let's say, person A and person B, and person B is the one who has the benefit of the hold harmless clause where they're not going to be held liable. What happens when person A surrenders the car, falls behind? What's going to happen? Well, it's going to affect person B's credit score. They can dispute that all they want with the creditor, but at the end of the day, they signed a contract. Okay, but wait a minute. What about this hold harmless clause? Now I'm confused. Well, hold harmless means you're not going to hold them, they're not going to be held for that debt. But that's family court. That's not the original contract with the creditor. So if you have Bank One here, and Bank One, gave a loan to both of these people, just because a judge in family court accepted an agreement saying that B is not going to be responsible for the debt, does not change the original contract. So could person A surrender the vehicle, and then they come after person B, and person B made six months worth of payments? Could that person, person B, sue person A in family court and say, wait a minute, I had a hold harmless clause. I'm paying for this car. You need to pay me. Absolutely. That can absolutely be done. The problem? They file for bankruptcy, then the family court loses jurisdiction. Remember, federal court is up here, state court is down here. So once federal court says that person is no longer responsible for the debt, it all carries over here. So the hold harmless clause is standard. It should be put in every divorce agreement, but we need to understand what that means when it becomes in relation to debt and bankruptcy and liability. Now, you will put, and let me just go back there, you will list the co-debtor, you will list them on Schedule H so that they get notice as well. Now, when it comes to dealing with other issues, sometimes we have issues where, for example, if you don't have good credit, someone else got a car for you, but you're the one making payment. Okay, that's fine as long as you can prove that the payments were being made. Then you're okay. Now, what happens if it's the other way around? The debt's in your name, but someone else is paying for it. Same thing in reverse. You just basically need to have proof that the person is actually paying for the debt. Now, in this case, suppose the debt is someone else's. Let's say it's my brother's debt. Then that's fine. It's not like the expense doesn't exist. It does. I have to pay, whatever, $300 a month on my car. I'm going to go ahead and list that. And of course, the trustee will see that the debt's not in your name, but as long as you have proof that these payments are being made from day one of the loan, there shouldn't be any issue with that. All right. So just keep that in mind. That is a common issue. Sometimes people have they don't even get to do the co-debtor part like Schedule H. They just strictly are either paying for the car or the car's in their name, and they're the ones that are filing for bankruptcy. Then we'll get into that issue of reaffirmation agreement, that even if I'm filing for bankruptcy, but it's really someone else, my cousin who uses the car, has been paying for it, again, that's fine. But what you got to do is just have proof of everything for the trustee. That's going to show any bank statements that confirm I've never paid for this car, or if it's the other way around where the debt, it's not in my name, they say I pay for the car every month, but it's in my cousin's name. Right. So as long as we have those expenses documented, everything will be okay. Now, finally, let's talk about some issues as well, especially when it comes to dealing with categorizing the debt and all the other issues of when there's collection notices. Sometimes you'd be surprised how many different collection agencies took over. For me, an abundance of a caution, even though I know debt one here has been sold to this company and they sold to this one and then they sold to this one, I just list everybody. It's going to take an extra minute or two, but at least I don't have to deal with it. I don't have a client calling me later on saying you didn't list the debt. Okay, it doesn't matter. I'm not going to explain the details to a client of how just the fact that I listed the debt is good enough. It's just easier so that everybody gets notice. So no one contacts the client and the creditor doesn't even do something else like start calling your office and wasting your time as well. So I do list everybody. I don't care how many times that debt has been sold over. Now, when it comes to hospital bills, I just put here, this is more like this is where your ears should perk up and the radar should go off just to make sure there's any issue. There's only one of two ways that these hospital bills are going to come into play. And either because you went to the hospital, because you were sick, or maybe there's an injury involved. If there's an injury involved, remember we're now dealing with the lawsuit. That's going to be listed on SOFA, Statement of Financial Affairs, or maybe there's no lawsuit. Maybe you're just still in the beginning phases, let's say, of treatments and all that. That still has to be listed in the schedule, and the attorney who's representing the client and the personal injury suit will be listed as well. Now, that's where these lawsuits come in. The other possible, explanation is maybe they're just being sued for hospital bills because they were sick, and that's fine. Same thing. You list the debt on SOFA, and then just make sure that just list it also as a debt on Schedule F since it's unsecured debt. Now, a lot of times I put notice only. That's what most lawyers do. You have these accounts that just basically, they bought it from whatever original creditor and they're just sending letters every week, multiple letters because they do get annoying, saying, are you going to pay? Are you going to pay? This is how much you're going to pay, etc. There's really this kind of, I guess you can tie it into deficiency judgment. We don't have a concrete number yet. And sometimes you're just sending out the letters. So you can put notice only is usually okay. And then as a balance, you put zero. Now, part of that, I think, again, I like that idea is because we're not duplicating all these issues. So, for example, if you have a debt with Bank of America and that was for 20,000, and now you just get a letter from a creditor saying, hey, you owe us 20,000, pay up. Well, when you put another 20, you see how we're starting to duplicate this. And then all of a sudden, we have the issue of, again, too much debt, more questions going to be asked by the trustee, maybe more documentation, maybe the U.S. trustee's office get involved. So it's important to make sure you're not duplicating it. And that's why it's just easy to put notice only. As a matter of fact, I just finished a blog post on student loans. There was an issue with Nelnet, who transferred their student loans to Mohila. So all of you with student loans, listen up. And they made a mistake. So what happened was Nelnet correctly reported that they had, the debt of whoever. The problem is once they transferred that debt to Mohila, guess what? Mohila is also reporting. There's my great handwriting. Mohila is also reporting the same debt. So all of a sudden you went from 50,000 to 100,000, and you can imagine what that does to your credit score. So I'll post that link in the description, so in case you guys are facing that issue, know someone that is. But you see how things can change all of a sudden. And again, that would lead to a lot of questions, not with student loans, but if there's three different collection agencies that took over and you've now multiplied this debt three more times over, yeah, it's going to lead to problems. So just notice only and balance zero is usually good enough. If they're suing already the client or the debtor, then that could be listed in SOFA, Statement of Financial Affairs, and remember to list it as well and under Schedule F, and just send notice to the attorney. We need to understand that these cases the attorneys have, they work on volume. And you can imagine how many people have credit cards and how many credit cards are attached to one particular lender. So just sending the lender may not be enough, especially since the lender, hired the lawyer to deal with the lawsuit. The reality is the lawyer is not working inside the lender's office. They're hired out. They get hired out by these creditors. So it's just better to notice the lawyer. That way, if there is a case pending in state court for the lawsuit, then simply the lawyer can go ahead and file a voluntary dismissal, since there's that automatic stay when it comes to bankruptcy being filed. Okay. So we are done with chapter 15. Any questions, as always, feel free to post them in the comment section below, and I'll be more than happy to respond to you. All right. Take care, everyone. And coming up next, chapter 16.